If you and your spouse have assets in a trust, what happens on divorce? Hi, I'm Simon Dippenaar and I'm a family lawyer. Trust and estate planning expert Phia Spuy has recently written about the treatment of assets held in trust when it comes to divorce. This is a very complex legal issue, so I'll try to explain it in simple terms. If your marriage crumbles after a few short years, you may have limited assets to divide. But if you have been married for decades, if you have set up trust structures, which is a common device for ensuring assets benefit children of the marriage, the divorce settlement can become very thorny. Courts will ask a number of questions in determining entitlement to assets in a trust upon divorce. Is the trust a genuine trust or a corporate veil? The court may disregard the trust if it appears to have been set up to mislead others, such as a spouse. When was the trust created? If one person transfers assets into a trust with the express intention of deceiving or defrauding a spouse of their potential claims in a divorce action, the validity of the trust may be questioned. The trust founder will not have acted in bona fides, good faith, and this will render the trust invalid. What was the founder's intention? If a couple married in community of property transfers joint estates into trust for their children's benefit, one spouse may apply to court to set the trust aside on divorce. In this case, the assets would form part of the communal estate. Otherwise, the assets would not be able to be divided as part of the joint estate as they are stuck in a trust, and this may not yield a fair division of assets. Is there a conflict of interest? If one spouse is a trustee and the other is a beneficiary, there may be a conflict of interest when it comes to divorce. This structure generally places the non-beneficiary in a compromising situation and is not a recommended trust structure for a married couple. How were the assets moved into the trust? When property is transferred into a trust, it is either via donation or sale, whereas donations tax is payable on donations. A sale is often reflected as a loan account in favor of the seller and an asset in the estate of the transferor. This asset will be taken into account in the divorce. Does this mean setting up a trust is a bad thing? No, it doesn't. Trusts are legitimate and useful legal structures. They can have tax advantages and protect the interests of beneficiaries. But there are some steps you can take to ensure you don't wind up in hot water should your marriage not go the distance. Before getting married, think long and hard about your marital regime. For many modern couples, marriage in community of property is no longer the most suitable option. Marriage out of community of property, with or without the accrual, may be a smarter choice. The anti-nuptial contract should reflect your respective rights to any assets, including any interests in trusts in the event of divorce. If you've already married and not sure if your current regime is still appropriate, you may consider a post-nuptial contract, which allows you to change your marital property regime. Any property purchased during your marriage should be carefully discussed and documented so you both receive a fair share should the marriage end in divorce. Think carefully about transferring the property into a trust. If you opt to set up a trust, both spouses should be trustees and beneficiaries. Make sure the terms of the trust instrument are clear and fair so neither party can influence the trustees to benefit them to the detriment of the other spouse. If you are considering marriage and want help with an anti-nuptial contract, or you're thinking about changing your regime via a post-nuptial contract, I can help. Give me a call on 086 099 5146 or email me. I'll call you back and we can arrange a consultation to suit you either in person or online.